Mr. Herman, you're up.
All right, thank you. May it please the court. I'm Jason Herman and represent Virginia Sours in this case, and I'd like to reserve 5 minutes for rebuttal if I could.
Sure.
The primary issue in this case is whether Four Loko, which is a drink that the evidence shows does not function like ordinary alcohol, should be treated the same as beer or other ordinary unadulterated drinks. The case law surrounding normal alcoholic beverages includes assumptions of facts that are so common to the human experience that they're baked into the legal analysis. Essentially, everyone knows how alcohol works, so it can't be dangerous. But those factual assumptions that underlie the legal reasoning in those cases aren't true in this case, or at least the credible record evidence taken in the light most favorable to Ms. Sours establishes that those factual assumptions are not always right, and specifically not right in this case. A normal alcoholic beverage is not unreasonably dangerous under Florida law because the dangers associated with it are exactly what everyone expects from alcohol. And following that reasoning, the trial court found that Four Loko was not unreasonably dangerous because it contained alcohol. But one of the major factual issues in this case is whether Four Loko was actually a normal alcoholic beverage with the normal dangers of alcohol associated with it. And if a jury finds that Four Loko is a normal alcoholic beverage with those same risks, then Stop and Shop should prevail on this issue below. But that's not a given factually, because there's record evidence from an expert witness, Dr. Goldberger, who's a toxicologist. He actually was involved in this case because he was hired by the state to help prosecute Virginia Sours. And he testified that the combination of ingredients in Four Loko, particularly the stimulants mixed with the alcohol, creates a different risk and a different physiological effect than alcohol, ordinary alcohol. And these risks, these dangers and risks include that people don't appreciate the risk that they take, including the risk of operating a vehicle. He said it removes the filter that people have from doing dangerous things, and it masks the effect of alcohol so that someone doesn't realize that they are drunk when they are. And this is not a danger that the public was aware of with Four Loko. Dr. Goldberger testified that he didn't believe that Ms. Sours would have known what to expect from Four Loko, even though she probably did know what to expect from alcohol without the additive of caffeine and the other stimulants there.
Mr. Herman, all of the effects that you just described are also the effects of alcohol, correct? You can't appreciate that you're intoxicated or how much you're impaired. You make poor decisions. Those are all known risks of alcohol itself, correct?
When someone is drinking alcohol, they can become impaired. The idea that someone who has alcohol in their system to the point of intoxication doesn't realize that they are, though, is not what the expert testified to. What he said is that with these really, really high doses of caffeine, that someone will, he called it a wider weight drunk, that their body is telling them they're sober, but they have all the problems that come with being intoxicated. And so that's where the difference is. And then because of that, there is an amplified reduction of the filter for risk.
So what it does is it amplifies the effect of the alcohol.
It's a greater effect than just alcohol, but the biggest thing is that it removes the ability to feel that you're intoxicated and that you should not be doing the things that you shouldn't do after you've become intoxicated, because this caffeine makes it seem to your mind and your body as if you are sober, but you are not. And that's after just one can of Four Loko. One can is essentially multiple Red Bulls and like 5 beers. So the idea is that when you drink one of these, it may seem like I've had one drink, shouldn't be intoxicated. The body doesn't feel intoxicated, but the person is. And that opinion that Dr. Goldberger gave, it's not an outlier. You know, he's not the only person saying this. In the record, we've got an FDA warning letter, and it states that the combination of the stimulants in Four Loko with the alcohol presents an unusual risk of health and safety, and also that consumers don't appreciate the potential risks associated with consuming the product. And in response to that warning letter that the FDA issued, Four Loko argued the same thing that's being argued in this case, which is that the effects of alcohol are well known, so it's not dangerous. That argument did not fly in the FDA, and ultimately the product Four Loko was pulled off the shelves. And we think here, the same result, should be reached here, except the jury should decide, is this a dangerous product or not? That same analysis also applies to the trial court's decision on causation, which was based on the conclusion that Ms. Sowards became voluntarily intoxicated. And that would break the causal chain. And it's a normal factual assumption that when people drink an alcoholic beverage, any intoxication that follows is voluntary. But that's not what Dr. Goldberger testified to. He said Ms. Sowards became involuntarily intoxicated, which is what led to this accident. She drank a single can of Four Loko. That's what is intended by the seller. That single can caused a state of involuntary intoxication per Dr. Goldberger. And unlike voluntary intoxication, the causal chain isn't broken then. And those effects, per Dr. Goldberger, they weren't foreseeable to Ms. Sowards, but it's completely foreseeable to a seller of one single can of a beverage that the consumer is going to drink it. And that's not misuse. That's just the way it's intended to be used, to drink one can. So although it's understandable to automatically assume that Four Loko operates just like any other alcohol in history, in this case, it required the trial court to completely disregard an expert whose testimony was not contradicted by another expert, nor challenged on Daubert grounds. And while it makes sense to go into cases involving alcoholic beverages with these assumptions in the background, maybe even as presumptions, the trial court should not have disregarded Dr. Goldberger entirely. Just like in a rear end collision case where fault is presumed to be on the car in the back, because that's normally how the world works. Sometimes though, the facts as they're interpreted through an expert's lenses tell a different story. And that's what's happened here. We have an expert who says the world here didn't work the way it normally does. So this isn't a pure legal issue. It's one that's mixed with fact. And if the facts bear out that Four Loko has all the normal known risks of alcohol, then the jury should find for the defendant on this issue. We've suggested a special interrogatory for the verdict form in our brief that we think gets at this issue. But whether that's used or not, the trial court's decision on this should be reversed, and this should be remanded for a fact finder to determine if this product was unreasonably dangerous or if the causal chain was broken. Moving on to the next issue, which is preemption, which was another grounds for the summary judgment that was entered. Federal law requires disclosure of a list of ingredients to the TTB, the Alcohol, Tobacco, and Trade Bureau, which is an organization within the Treasury Department. And that requirement that ingredients be listed and provided does not mean that state court products liability cases are preempted by federal law, nor do specific labeling requirements imposed by the federal government preempt all state laws involving beverages containing alcohol. So there's two broad categories of preemption. The most obvious one, the cleanest one, is express preemption, and that's not in play here. No one argues that it is. Instead, what's being argued are two different types of implied preemption, either implied field preemption or implied conflict preemption. And there's a presumption against federal preemption when you're not dealing with an express preemption. And overcoming that presumption requires a few things. First is a narrowly defined field that's preempted, and the order here doesn't do that. The brief, Stop and Shop's brief, suggests that the field that is meant to be preempted is, quote, the regulation of alcoholic beverages. That's not narrow, it's very broad, and it's not consistent with laws in the United States, which across states include different laws about when alcohol and where alcohol can be sold, the amount, the quantity of alcohol in a can, the size of beer, the percentage of alcohol in beer or liquor. all those things have a variety of laws across the country, and they're not preempted by these laws.
So the
Secondly,
ATTB purpose basically is ensuring that you're not running an illegal still, right? That it's being taxed, that it's being regulated in the sense that warning labels are being put on it. Your position is it has nothing to do with an evaluation of the safety to the consumer of the contents. Is that correct?
that's right, Your Honor. And this is a part of the Treasury Department, is looking for uniformity in trade and looking to tax things appropriately.
And its power to do all this comes primarily out of the Internal Revenue Code.
That's right.
And not health and safety.
Yes, Your Honor.
Okay.
And so we think there's grounds for reversal just on the first prong that can't be met here, both because it wasn't addressed, but even if it had been addressed, it wouldn't have shown that this was appropriate to be preempted by federal law. But secondly, there's got to be an analysis by the court of the structure and the purpose of the federal laws compared to the state laws that are to be preempted. Do they really compete with each other? And again, the order doesn't do that. But if you look at these regulations, which are trade and tax type regulations, and you compare them to a products liability case, they don't contradict. There's no conflict there. The TTB doesn't regulate the safety of these products. It just requires an ingredient list be submitted and that the product can end up containing those ingredients. But sellers and manufacturers are free to change ingredients, and they do so to fit the myriad of state laws involving alcohol content and all the rest of the things across our country. And so holding a seller of a bad product liable for the effects of that product doesn't undercut the federal government's requirement that ingredients be submitted to the TTB. And if it turns out those ingredients cause harm, that, like I said, the manufacturer can change its recipe to comply, or they can change its recipe or pull its product to guard the public. And like I said, they do that on a case-by-case basis across the states to match the law. Also, state pressure is what ultimately led to these types of products being pulled out of the market. So state attorneys generals pressured the manufacturers of heavily caffeinated drinks to pull them off the shelves. Miller's Coors, Anheuser-Busch, they both pulled their products that were similar to this in response to that pressure. Four Loko stayed on the shelves until those states convinced the FDA to step in and ask Four Loko to verify that it was generally recognized as safe, which it couldn't do, and the product was pulled. Those interactions, which involved a heavy influence from state governments, didn't violate any principles of federalism. And the same is true here for a private citizen using state law to hold a seller liable for a bad product. So these state law claims are not preempted, and the trial court also failed to conduct the requisite analysis to establish a non-express preemption as well. And so for these reasons—
Could you discuss the effect or involvement of Florida's dram shop law in this case?
I'm sorry, I couldn't hear that.
What is the effect of Florida's dram shop liability principles in this case?
They don't apply in this case. This is a products liability, straight products liability case.
Well, generally the law is that a vendor isn't liable for injury caused as a result of consuming the alcoholic beverage. Wouldn't that apply, whether it's products liability or intentional tort or negligent tort?
Well, in this case,
it doesn't say the law isn't that a vendor isn't liable for negligently serving someone. It says they're not liable for injury or death or damage, brother. Aren't you alleging injury or damage?
Yeah, injury or damage is certainly being alleged in this case. Although the position being taken here is not that this is an ordinary alcohol beverage is being served like in a bar or in from a liquor store. That this particular product is the combination with the stimulants that makes for an unreasonably dangerous product. And so the analysis is going to is going to track.
But could the same be said of someone, say someone consumes, I don't know, a bunch of White Russians, which, you know, sweet, nice tasting drink, you don't necessarily taste alcohol in it. People have trouble perhaps regulating how much alcohol they consume. Wouldn't you be making the same argument then?
I don't think we could make the same argument there.
Assuming I know what White Russians taste like, I've heard this, but.
Well, the expert in this case actually talked about a even closer, analogy, which is Red Bull and vodka, which is a caffeinated beverage. And he was asked, what's the difference? Why wouldn't that be an issue as well? And his testimony was that doesn't, we've got a much different risk with Four Loko because of the extremely high level of.
Well, yeah, but aren't we in the situation of, you're describing these differences, but we have we have Dram Shop law, we have Dram Shop Act in Florida. So maybe these arguments should be made to the legislature.
The Dram Shop law doesn't protect sellers of all products. If you'd mixed in poison with your White Russians, it would certainly not prevent the seller of that.
There was poison mixed in with this. I mean, and when you get down to like what is mixed in, again, we're back to, various mixed drinks, rum and Coke. I need to, taking up your time right at the end. You're right at the start of your rebuttal time. So, use the 5 minutes as you wish, Mr. Herman.
All right, I'll wrap up this line. So yes, this is not poison, but, the FDA determined this was an adulterated drink because of the high levels of caffeine. And
Sure.
So the idea here is not a case for a store selling alcohol, even if it tasted good or sweet or anything else. It's because this product contained the high level of stimulants that makes for this cause of action. And I agree, if this was just a pure alcohol case, not only would we lose for, on causation and not being unreasonably dangerous, but the Dram Shop issue would be a loser for us as well. Okay. I'll say the rest of my time for rebuttal. Thank you.
Yeah, 4.5 minutes. How's that? Okay. Mr. Appley.
Thank you. My name is Aaron Prue. I represent R&J Enterprises of Tampa, doing business as Stop and Shop. I just briefly wanted to begin by making sure the court is aware that the only issue on appeal is the strict liability claim for defective and unreasonably dangerous product. The answer brief that I filed mentions the abandonment of the negligent defective product, negligent failure to warn, and strict liability failure to warn claims. And I didn't hear anything different from the plaintiff in the reply brief or today at oral argument. So the first issue is that the trial court correctly granted summary judgment.
Forgive me, I am unmuted now. You won't have to just see my lips moving without sound. With regard to the product, my understanding is that the legislature has imposed a statutory legal limit of 0.08% blood alcohol content. And as I look at the Four Loko product, the advertisement indicates that it's 12% of alcohol by weight, and it's 23.5% of liquid. Do we know what a normal person, say of a body weight of 120 pounds would be if they drank one can? Would that put you over the legal limit with that many ounces of alcoholic beverage in it?
I don't know, and I don't believe.
So the record's silent. The advertisement is drink responsibly, but my concern is I look at a product, if you drink one can and you're responsible, you think it's like a can of beer and it's got enough alcohol to push you over the legal limit. That has a great concern for public safety, and that might have an impact on determining whether or not this is unreasonably dangerous, because we know how many deaths and people are made by the operation of a motor vehicle under the influence. They're multi-ton machines.
Right. There is case law, though, saying that even beverages like Everclear, which I believe is 80% alcohol or something like that, So if you were to have a shot of Everclear, which is legal and not deemed unreasonably dangerous, that would be far more alcohol with far less liquid than Four Loko.
Is
So
it
there's never been any,
advertised as an alcoholic beverage, or is it advertised as some sort of energy drink? The
this,
beverage you're mentioning.
again, this is not a warning case. This is
I
a strict
understand that,
liability
but we're talking
protection.
about all the factors that may or may not lead to unreasonably dangerous to a consumer. I mean, my concern is how about someone walking down the street getting nailed by some unsuspecting college student who's of legal limit and has drank a can or two of this beverage and finds out when the police officer stops them that you have just blown over the legal limit and you've said, I only had one.
Yeah, well, in this case, the person who was drinking the Four Loko was not unsuspecting.
That is
The
correct.
record,
She has consumed other things before she purchased this beverage. Does that impact our analysis as to whether or not this is an unreasonably dangerous product? That is the
for
nature
this,
of
well,
this consumer?
right, so what you have in the strict liability unreasonably dangerous product case, what you have is the long line of alcohol cases that the court is well aware of, that alcohol itself is not unreasonably dangerous as a matter of law. And there is no fact question because Restatement Second of Torts 402A says that unreasonably dangerous means that the product was in a, quote, uncontemplated condition, end quote, with, quote, unexpected dangers, end quote. This, the plaintiff managed to get all the way through the initial portion of oral argument without mentioning the Cook case,
So
which is the,
it would be an expected danger to know that if you drink an alcoholic beverage, no matter what quantity, you would know that your reflexes will slow depending upon the quantity, that it's a depressant, I think as well. So operationally, you already noticed by ordinary experience that any alcohol will have an impact.
exactly. So, and that's the point I was making about Everclear. You could have unsuspecting college students drinking Everclear, and maybe they think it's the same as vodka. But that Everclear product, that case law found to be not unreasonably dangerous, has way more alcohol than a vodka and Four Loko. So if the argument worked that Your Honor was just saying about the unsuspecting college student for Four Loko, then we would have to apply that to any strong alcoholic beverage that can deliver a large amount of alcohol per volume.
So under this, go ahead, please.
Thank you. Isn't Mr. Herman's point that though this is not just pure alcohol and it is a different product, or it is arguably a different product, which it should be submitted to a jury? So isn't you're pointing us to a certain line of case law based on an assumption, and Mr. Herman's position, plaintiff's position, is that's the wrong framework. We don't even know, it's a factual question, which framework we're even operating in.
Right. And so that's why I was about to begin talking about the Cook case, which is the only case to apply Florida law to an energy drink. In that case, the same exact arguments made by Sowards were made by the plaintiff. That it was designed and marketed to appeal to younger drinkers. It's got this whole energy drink thing to it. It has the addition of the stimulants, which make the drinker perceive that they can drink without getting drunk, because it is scientifically established that if you have caffeine or other stimulants mixed with alcohol, you do feel less intoxicated. But as the science goes, the drinker is not less intoxicated, and the drinker's motor functions do diminish. These are all the arguments that are made by Sowards. They're all the same arguments that were made by Cook, which is the only case to apply Florida law to an energy drink. And the court rejected the argument that we should now enter a different analysis and open up to fact analysis as opposed to just still deciding as a matter of law, any drink with alcohol is not unreasonably dangerous because we know of the dangers of alcohol. And the specific reasoning that the Cook court took after presenting the regular unadulterated alcohol was to say that the reason why we have, the reason why alcohol is not unreasonably dangerous is because of the imputation of knowledge. The imputation of knowledge that drinking may cause impairment. So you already know that ahead of time. There's nothing on the can, there's nothing in a commercial, there's nothing in an advertisement that says, oh, by the way, you will not be drunk, your motor functions will be fine. So the same.
Can we stop at that point about the imputation of knowledge that it may cause impairment? And that would be the custom and practice probably since I'm the oldest person on the court here, back when I was in high school in the other century. But my concern here is arguably this is not like a can of alcoholic beverage like a beer, Bud, Coors, or a mixed drink. This has an ingredient or a series of ingredients that are added on or added into the alcoholic beverage so as to stifle, hide, or conceal the effects of impairment, of which a person may say, oh, I'm starting to feel that buzz, I need to stop. Here, you don't feel anything. The manufacturer has created a product to disguise its impact, either intentionally or unintentionally. And going back to what Judge Rothstein Yoakum said, does that change our paradigm, our framework for analysis, that this is not merely an alcoholic beverage, this is a product with a disguise factor?
Well, the word disguise.
Yeah, I know it's not an articulate. That's the best I could do to make sure you understood my question. So
okay.
I don't use it in a legal sense or in a sense of the
Okay.
people. It's just the impact to the. It might slow down someone. That was the best word I could come up with.
Sure, I get it. So I won't go down that road then, and I'll just stick to the point.
It hides. Operationally, it
Sure.
hides.
Right. Scientifically, it is known that it does hide the effect of alcohol. But before the person drank that can of Four Loko or Tilt or juice, all these other energy drinks, or before you mix a shot of vodka with Red Bull, you know that you are drinking alcohol. The imputation of knowledge does not disappear just because other ingredients are added to the alcohol. You already know ahead of time. Every person is charged with the knowledge that alcohol does affect your motor functions. You cannot later say, well, I know that I used to be charged with this imputation of knowledge, but we want to take away the imputation of knowledge because there's this other energy substance or caffeine in the beverage. You're still charged with the imputation of knowledge because you know that there is alcohol in it. And this is what the Cook case said, the only case to apply a Florida law to an energy plus alcohol.
Regarding the Cook case, Judge Hernandez Covington's district court order, she goes through the list. I think she starts off with failure to warn. For the purpose of this case, as you point out, we are at a products liability standard. There is no failure to warn claim. Which section of that opinion do you think is the most relevant that we should focus on? Is it the design defect or the negligence? Because there's captions.
They do that opinion, that order, reasoned order has a section for both the unreasonable dangerousness, as I just described. It just said the reason why we have why alcohol is not unreasonably dangerous is because it doesn't meet the standard of because alcohol does its intended effect. It does create the mind altering effect that it is intended to do, so it's not unreasonably dangerous. just because you're adding, this is from that section, just because you're adding caffeine doesn't change the fact that we know alcohol has its intended effects. So that's how they decided that. And then the other portion of that opinion dealt with the foreseeability analysis, which is a very, and you just heard the same thing for plaintiff, the foreseeability analysis is very close to the unreasonably dangerous analysis, because both of them are said as a matter of law. And I'm sorry, I shouldn't have said foreseeability, I should have said causation. The causation analysis portion of Cook is also directly on point with our case, because in Florida, the ingestion of alcohol is the superseding event. So your same reason as Your Honor was asking about the dram shop law. The pouring of the dram as it used to be measured for the person ingesting the alcohol is not some kind of event that caused the accident. As a matter of law, we take that away from the jury and we say that the intervening act, the sole act of the ingestion of the alcohol, whether it's alcohol with other stimulants, whether it's alcohol that's highly concentrated, none of that matters. We've decided as a state, and most states in the nation have decided that as a matter of law, it's not unreasonably dangerous, and also as a matter of law, causation cannot be established. So that case does both of those things.
When we're speaking of Cook, we're talking about Judge Covington's second order, right? The one at 872 F sub second, not the first one that came out in 2011, right?
I actually don't have the site in front of me.
There's one at 829 that came out in FSUP at 2011, but I think the one that you are referring to about defective product came out at 872 FSUP in 2012, and that's the one I think we were you were talking of. And I may have confused you because I think I saw the first one, and I will make sure that I didn't lead you astray. I want to let you know that there were two.
Okay.
And I understand which one you were talking about is the second one because it speaks directly of products liability.
Right. And the site is in all the briefs. All both defendants cited that case in the court below.
Don't worry, I have them.
Here.
One by photocopy, one by handwriting, the old-fashioned way.
Okay. And I would just add what is different in this case that makes this case easier for the defense than in Cook is page 3 of the answer brief discusses the multiple record sites where the plaintiff had admitted to consuming alcohol underage in the past and knowing its effects, admitted to consuming caffeine in the past, knowing its effects, and consumed alcohol plus caffeine in a beverage called Tilt and knowing its effects. So everything that you heard from the plaintiff about trying to create this fact question by inserting this affidavit of somebody talking about all of the effects of the unknown effects, or one of you on the panel said the unsuspecting college student. In this case, as applied specifically to this plaintiff, she did have knowledge of the effects of consuming alcohol plus caffeine. So in a sense, then there's no need to even go to, for this plaintiff, the imputation of knowledge. It's still there, but plaintiff in this case has actual knowledge. And I would point out another reason to reject the question of fact allegedly created by the expert retained by plaintiff is that the argument is not in the motion for summary judgment or the hearing transcript. You can see that at 2793 to 2840. That argument is not even in there, so it's waived anyway. I'm gonna move now to preemption because it seems like well, I know what the plaintiff's argument is that the plaintiff has actually cited some recent cases, and it sounded like the panel was agreeing with the plaintiff about the preemption argument not working for the strict liability claim because the failure to warn the labeling is all that is regulated by the ATTTB. And this is actually incorrect. And this is the first time I've presented this argument. It was not presented below, and that is because the plaintiff never raised the argument against the portion of the regulations that do regulate the actual ingredients, not the labels. And so I had no opportunity to make this argument because it did not come out until the reply brief. And so I'm going to address those new cases that, again, I believe they're waived, but I do need to go over that because I didn't have an opportunity after the reply brief. So
To give you a heads up, Mr. Pruitt, you're down to 2 minutes. So
okay, I can do it in 2 minutes. Alcohol and Tobacco Tax and Trade Bureau was created in 2003 when it split the Bureau of Alcohol and Firearms under Title 27 of the CFR into the ATTTB and the ATF. Title 27, Chapter 8 has 2 subchapters. One is for alcohol administration and one is for alcohol beverage labeling. Chapter 27 of the Code of Federal Regulations is not just labeling. Parts 4, 5, 7, 13, and 16 are for labeling, but part 25 is not. It's a separate section for beer and I believe malt beverages. Subpart J is for labels, but subpart F is our subpart. It has 4 sections: formulas for fermented products, filing formulas, formula information, and new and superseding formulas. So if we use the implied field preemption, if we apply implied field preemption to that, we can see that one of those subsections requires non-traditional products, meaning not regular alcohol, meaning alcohol that has additives, requires the submission of a proposal, including a detailed description of the proposed process, a list of each separate ingredient, and the ATTB has the right at any time to quote, require you to file additional information concerning a fermented product, ingredients, or processes in order to determine whether a formula should be approved. So this product was approved at the time. I understand that later on the FDA found, as plaintiff said, but at the time, there was nothing wrong within the ATTTB regulating the ingredients. And so if this court were to now say that's unreasonably dangerous when the ATTTB has already approved this formula, that would now be the kind of contradiction that the preemption clause would prohibit. And it would say that the ATTTB at the time allowed for these ingredients, and no state court can now enter an opinion that would find the product to be unreasonably dangerous. All of the cases cited by Sowards are distinguished because they are all labeling cases. Yours is a 4 Loko case from New York. That's in the reply brief. That is a labeling case, not an ingredients case.
Mr. Pruitt, you need to wrap up.
Okay. The only other thing that the cases have are anti-preemption clause built into them, like Wyeth, the Wyeth case. So they're all distinguished, and for all of the reasons that rendered by the trial court, this court should affirm that order. Thank you.
Okay, Mr. Herman, you're up. 4.5 minutes.
Thank you. There was a question about whether one can of Four Loko can push someone over the limits. At page 1264 of the record, you'll see that Dr. Goldberger testified that Ms. Sowards' blood alcohol level was consistent with a can of Four Loko. Also talking about Tilt, she did drink a drink called Tilt. It used to be a caffeinated beverage. The caffeine had been removed 18 months prior to her drinking it because Tilt was one of those, was manufactured by one of the big manufacturers who pulled their caffeine out in response to the attorneys generals. By the way, Four Loko currently is on the shelves too, just doesn't have caffeine in it. So Tilt took that path earlier. Looking at the Cook case was a motion to dismiss decision out of a federal trial court. It's no more persuasive than Judge Isom's decision in this case, where she denied a motion to dismiss in this case for the same reasons that were argued in Cook. And here, since we got past the motion to dismiss stage, evidence was developed. And we've got evidence in the record now in the form of an expert opinion that takes the factual assumptions that Judge Covington made in Cook based on the law and says those don't apply here. Those assumptions are not true in this case. And finally, to speak to the point that consumers already know ahead of time what they're getting into when they drink a can of anything that includes alcohol, that's just not what the record shows here. We've got credible expert opinion backed up by what the FDA concluded, that consumers do not appreciate the risk when they drink a can of Four Loko, and they do not understand the effects that they're going to have on them when they drink this. So unless there's further questions, we ask that you reverse, please.
Okay, thank you both very much. In order to leave our virtual courtroom, you should click the leave button in the lower left-hand corner, right-hand corner rather, of your Zoom screen.
Thank you.